Previously on Stay in Your Lane,
just keeping an eye on what's been paid, what hasn't, looking for discrepancies in the person you're used to dealing with. It's their things that are just off a little bit in a signature block, various things like that, because you will have, I've seen it happen personally in my practice a bunch of times where someone has paid in different industries, not just transportation, where someone pays a fraudulent invoice. And that's tough. And I don't think you get a tax break when you do that either. I actually don't think you do. I'd have to look at that, but it's tough.
Well, Thomas and I have been working together, and Thomas has actually upgraded all of our engagement contracts with carriers. So you have a shipper carrier, shipper broker, broker carrier. So all this was done and designed for protection, layers of protection of, our brand to minimize any issues that we may encounter out there. So Thomas and I have worked together a lot. I'm very curious about the language on bills of lading, as old as it is, if it's still pertinent, and if you end up in court with some huge freight bill, multiple invoices, and just a deck, say. Some carriers might do $50,000 worth of work for a customer in a day. That's not my situation, but the stakes can be high. And so I wanted to talk a little bit about the Section 7 to make sure that the execution of our BOLs by carriers and customers that make pickup, that were covered in this. I feel like it's almost impossible if somebody wants to expose you somehow, in any of the processes where you've got documentation that you think you built out strong enough case for protection. It still happens if they choose to do that.
So let me back up here, and I'm going to throw some things at you because Jim, we need to try and get you involved here. But I'm going to say this: if I'm a carrier and I do business, I pick up for you, let's say Slate, but I'm doing business through a broker, and the broker doesn't pay me. Right? They go out of business, leave me a huge bill, right? And you say, sorry, I'm covered contractually. I've seen attorneys go immediately and file against the consignee.
You and I have talked about this before, John, where we both remember some language that we couldn't find at that time, and we didn't put any resources into locating it. But ultimately, the party that prospered off the carrier's work or cost is responsible ultimately for the freight. Now, Thomas might be able, and Jim as well, maybe Pat knows too. And that's always the one hook that they have back into you. And if that's real and I've not experienced it enough, as I explained, I would like to determine eventually if that is a real thing, a real recourse for payment.
Well, I think initially what it does is it causes problems. Causes relationship problems between you and your customer, right? They start to say, hey, wait a minute. Do we really want to be in the middle of this? Now we're going to have to defend this. We didn't have it. We weren't supposed to pay the freight bill in the first place. So then they get on the phone with your legal arm on your organization and say, make this problem go away or we'll find another provider. Right? At some point in time, attorneys do this, right, Thomas?
They do.
I know they do. And so, at the end of the day, it maybe doesn't have as much to do with your contractual language of trying to eliminate all of the loopholes. At the end of the day, the attorney, the carrier that didn't get paid seeks an attorney out, not with the high scruples of Thomas Kern, not one with the character of Thomas Kern, but they reach out to somebody who says, I'm going to get you paid. I'll take this case. And they immediately file against the consignee and, file against you. But initially, first they'll go to the consignee and cause you problems right then and there. The phone's going to ring What, you guys aren't paying your bills? Why are we in the middle of this? We paid you for the product. It delivered to us. We're out. Make this go away. We've seen that happen.
Yes.
So I don't know that there's a contract that's going to beat these type of situations. Thomas, do you know?
Well, I think what you'll see is if it's a shipper who ships a lot to this customer, the consignee, they'll make it go away.
The shipper will make it go away if they were supposed to pay it.
Well, because the continued business with the customer is much more beneficial than the freight charge to a carrier one time or whatever the case may be.
Yep.
So it's sorry about that. Let us take care of this. Sometimes that will happen, and the shipper will then say to the broker, hey, make this, this should be you, or whatever the case may be. And those usually get resolved fairly quickly. The ones that you usually see go to at least a complaint get filed and then possibly a resolution later. I can tell you I've never gone to trial on a Section 7 bill. They all get worked out. But where you'll see them go a little further is if it's a shipper that doesn't do a whole lot of business with this customer, right? It's maybe a one-off, maybe a few things.
Where the risk reward isn't there to settle it.
Like, this is what the law says. Like, we signed the non-recourse section that says do not deliver this load if you haven't been paid, and you did it anyways. And again, each one is different, but I'm generalizing here. And so, consignee, that then falls onto you and your liability for this. So carrier, you can no longer look to us as the shipper. You need to look to the consignee as the party who will benefit from the receipt of these goods.
So that would be in a collect scenario then, right, Thomas, on Section 7?
Yeah.
Yep.
Yeah. And again, without looking at them, I don't want to generalize too much, but it can go either way, right? It can go back and forth, but it's generally like, hey, this has been prepaid. Don't give it to me unless you've been paid, or hey, on the collect side, don't deliver it unless you've been paid. And so they kind of volley liability back and forth. But you'll see more sort of dispute take place between the shipper and consignee in those situations where there's not a long-term relationship. And then that's where you kind of decide who's going to end up paying the carrier. I've seen it where they've split the baby in those situations. I've seen where the consignee paid.
It gets resolved, though.
Again, I've never taken one to trial on one of those. I've been on both sides of them, and they've never gotten to trial. It usually gets worked out, or one party just doesn't want to spend the legal fees anymore, something like that.
All right. Jim, what type of scenarios are you dealing with? Any of these at this level, or are you just initially dealing with smaller carriers, smaller operators that are getting burned by fraud, or brokers closing their doors? What are you seeing?
All right. So stuff that you guys are talking about with the shippers and their negotiations with brokers, that's something that the carriers don't see, because what the carriers have is they've got that contract with the broker and the agreement that they've made with the broker to make the shipment deliveries. So you made mention of don't deliver until you get paid. Well, that's not really an option for a carrier. They don't own the product.
Right.
So they've got a delivery in order to get paid from the broker. So a lot of times, that's not something that they can do. Now, as far as broker fraud and things along those lines, if a guy catches it before they make the delivery, they get in touch with us. We can usually get in touch with the shipper and make arrangements with the shipper so that the delivery is made and they get paid whatever the original contracted price was. If the delivery has already been made, trying to get paid after the fact is where they come into issues. If you've got a broker that's closed down, you file a claim against the bond, you're going to get pennies on the dollar. You can go back to the shipper and try and get paid from the shipper or the receiver, which then becomes a question of, are they going to be willing to pay a second time? Because obviously the broker has already been paying, and the shipper has the option of saying yes or no. A lot of these cases, when a guy runs a load and say the load's supposed to pay him $2,500, and now they didn't get paid, they don't really have the money to hire an attorney to file a lawsuit against the shipper, the broker, or anybody else, because they're operating on such a small profit margin. When they get taken advantage of like that, a lot of times it puts a guy out of business. So it's crucial that these guys are able to get paid for the work that they perform. I mean, they're the guy at the end. They're the one that's actually making that delivery so that the products from the shippers get delivered to the receivers so that the receivers can put that product out on the shelves and sell it. Now, it's that guy in the middle that's making that delivery. That's the guy that we need to make sure that we take care of. Putting these guys out of business, who's going to make the deliveries?
Well, I totally agree with you. So, Pat, do you have anything here that you'd like to question or ask from where we're at?
I only went to court once for this, and the judge says, the agreement that we had between ourselves and the broker, that name was not on the side of the truck. So that truck was not a part of the agreement. So we actually won in that ruling, but I don't know if that would be the case in every scenario.
So explain that to us.
So if my transportation agreement is with broker ABC,
Okay.
and the carrier takes me to court to get reimbursed, I have no contract with him. I have no contractual agreement with him.
But he delivered your product.
Correct.
Okay.
So I was no longer on the hook with that carrier because it wasn't a part of my contracted agreement.
Thomas, how do you handle that?
Who am I representing?
You're representing the carrier. I'm going to say you're representing the carrier in this scenario.
Right. So the carrier wouldn't be in privity of contract. Right. So again, we talked about the two schools of thought early. The school of thought, which is, I would say, the majority, which is carriers should get paid for some of the reasons Jim talked about. Like, you're not going to get stuff if there's no carriers. So they are very well protected, right? So you fall under this shipper pays twice thing. And if anybody Googles that, you can learn everything you ever want to know about shipper paying twice. And that's where we kind of can fall into these Section 7 issues underneath that. So if I'm representing the carrier there and the broker, I'm in contractual privity with the broker at that point, but the broker is not a viable option for payment, then I look to some of those equitable principles that I did deliver your product and I didn't get paid. So it's falls under that shipper pays twice situation where I look to straight bill of lading and, who signed what and what options I may have there. There's some circumstances where the carrier is just out of luck, and that's very unfortunate because they're probably the party that can withstand it the least. But there are oftentimes opportunities for them as well to use some of these tools, whether it be, and I know Jim's point is like, a lot of these guys can't go hire a lawyer, but if they can, there are some tools available to them that they could use in those situations.
Sometimes too, if you're working with them, they're willing to negotiate with you. At least that's what we've seen. Working directly with the carrier to come to some type of agreement where we're lots of times splitting it.
Jim, do you see that? Have you dealt with that where it gets split?
Yeah, we've dealt with some of the issues when we've reached out directly to a shipper on behalf of one of the carriers and negotiated. The carrier took a load from a broker at an elevated rate that the shipper wasn't even paying to the broker.
Continue watching on the next episode of the Stay in Your Lane podcast.